Um, our topic today, the third topic that we're doing this week, is the economic analysis of tort liability and insurance. Uh, I learned something about the history of this topic yesterday that I was not sure about. Um, this topic was first raised in the 1960s, a long time ago, 60 years ago, after a very, very talented law professor at Yale named Guido Calabresi read an article by Ronald Coase in the Journal of Law and Economics entitled The Problem of Social Cost. And he immediately saw that it might have an application in tort law. And I'm sure you're aware of what happened after this. One of the first articles published in the topic of law and economics was an article on tort law by Professor Guido Calabresi of the Yale Law School, who then wrote a book, an extraordinarily good and famous book that was published in 1970 called the Economic Analysis of Accident Law. Now that I didn't know that history until yesterday, but I wanted to note it because, as you can tell, a lot of law and economics stems from that incredible article by Professor Ronald Coase. Not just in property law, but as you probably know, contract law, tort law, corporate law, environmental law. That article, one father and thousands of children came from that one article. I haven't said this before, but I want to say it. I said this in the introduction to the marvelous book that we celebrated yesterday. It is, as somebody who's been involved in this topic almost from the beginning, almost roughly 1980, I should tell you that in the United States, law and economics was not a great success initially. I think many traditional lawyers were intrigued. There was something interesting in law and economics, but they weren't entirely sure that it was something that would really appeal to a wide audience in the field. And throughout the 1980s, I think there were more attacks against law and economics than there were articles that used its tools to analyze the law. You know, in the academic world, attacks are not entirely bad. If somebody is attacking your work, and that other person is an intelligent and thoughtful and kind person, then attacks make you rethink your material and cast it in a different way to try to address the criticisms. That struggle between law and economics people and the people who attacked it consumed the 1980s. And it wasn't until the 1990s that law and economics had such a firm place in American, North American, I'm including Canada, had such a firm place in legal scholarship and importantly in the legal curriculum of things that were taught, that I think you could say that the innovation had survived the attacks, responded to the attacks, and ultimately won. And here's a sign of the acceptance of law and economics that I want to alert you to. When I started teaching at the law school, I was the first person who didn't have a law degree who had ever taught in the law school. And the dean of the law school, who became a good friend, placed a young professor, a young law professor, in the classroom with me to make sure that he could help me in the case I needed help in talking about the subject to the law students. Within a couple of years, I was widely accepted by the students, the dean, the faculty, and it was a wonderful, wonderful experience. When I retired from the law school in 2010, in my last semester there, I taught the last course in law and economics that has ever been taught at the University of Illinois College of Law. For several years, I worried about that. I thought, now that I'm gone, is law and economics going to disappear? It's not. And I think this is a testament to how successful we have been, and that I hope you will be too. If you're really successful, you work yourself out of a job. And that's what we've done. We've been so successful in changing property law, contract law, less so tort law, but I'll talk about that in a minute, corporate law, which is basically the economics of corporations and other business associations, all of the regulated industry laws, administrative law, environmental law, everything. We've been so successful in changing those areas of the law that there really isn't a need for a separate course in law and economics, like the one I taught for many years. And that's a sign of success, not a sign of failure. We have had a tremendous impact both on the scholarship of the law and on the practice of law, and I think on the art of judging as well. So I just wanted to make those remarks because this marvelous book, I think you will see, is the first step in a long journey that will provide you with a great deal of satisfaction, because you're going to change the scholarship, the practice of law, and the art of judging in your country. So congratulations. It's a wonderful journey that you're on, and it's so satisfying. Okay, I better get to talk to my subject. The economic analysis of tort law, liability, and insurance. This is a topic that I have a particular fondness for, because it seems to me to be an area of the law in which the economic analysis should have been, I want to put it that way, should have been revolutionary. And the reason I say that is this is an area in which economics clears up some old puzzles that existed in the law, explains things that were not clear, and provides this area of law with a unifying explanation of why the field exists, why it has the divisions between negligence and strict liability, what the relationship is between safety regulation and private tort law, and so many other puzzles in tort law. And yet, I'll tell you this, I think that this is the area that among the areas in the law that ought to have been deeply affected by law and economics, this is the area where there has been, I believe, the least impact of our scholarship. I don't know why that is, but I hope it's changed soon. Anyway, okay, let's go to the third slide, Hitesh. I'm going to present this this topic, and I'm going to present it in a very, very stylized form first. I'm going to make some very restrictive assumptions. I'm going to assume that everybody involved in this model that I'm going to talk about is a rational decision maker. They know what they like and don't like. They can compute the happiness or the pleasure, the utility that they will get from different states of the world, and they don't make mistakes. I also want to assume, just for the time being, that there's no insurance. Thirdly, I want to assume that litigation is costless. And finally, I want to assume that there aren't any other public policies, safety regulation, for example, that is designed to cause people to take precaution. I'm going to relax these assumptions later. Most economists say that and they never do it. But I am going to relax these assumptions later, I promise you. And I want to stress to you again this very important point I hope I made Monday, that we're going to do this from the ex ante perspective. We're going to assume that the law has been articulated and disseminated, communicated, and that people know or can find out very easily what their responsibilities are for accidents. And they know, for example, what their exposure to tort liability, to paying damages or not receiving damages, depending on what decisions they make about precaution. Okay, next slide. What's the economic goal of tort law? First of all, why do we need a separate area of law for accidents between strangers? Well, as I tell you, and I've told my students for decades, the answer to almost any question is transaction costs. And here, that's the right answer. People who meet by accident, crash, they have an automobile accident, probably have had no previous connection with one another. They didn't bargain about what would happen if there was an accident. The costs of bargaining with everybody whom you might injure, or of their bargaining with you in the event that you injure them, those costs are much too high. And as a result, the ability of private bargaining to cause people to take the right amount of precaution is very, very limited. It only exists in certain business relationships. For example, the relationship between a patient and his or her physician, or the hospital. But it doesn't exist at large. I don't know when the next accident I'm going to be involved in is going to occur. I hope never. But I don't know who's going to injure me, so I can't go to them, and I have to figure out a way to deal with the costs that arrive from the accident. Well, as I mentioned, the great seminal book and articles that talked about the economic goal of tort law was this marvelous book by Guido Calabresi, then a professor at Yale Law School, then the dean at Yale Law School, and then a federal judge. He was appointed to a federal judgeship by his former student, President Bill Clinton. And this book, The Cost of Accidents, in 1970, is still worth reading. Professor Calabresi, Judge Calabresi, is the one who established the economic goal for tort law, and it is to minimize the social costs of accidents. As you know, social costs are different from private costs, and one of the tasks of a well-functioning legal system is to get people who are imposing social costs on other people to internalize those costs. That is, to take those costs into account, not just to worry about their own costs, but the costs that they might inflict on others. Calabresi identified three elements of the social costs of accidents: the precaution costs, taken by everybody because you do not know if you're going to be an injurer or a victim. So everybody's got to take precautionary costs. The accident losses, if there is an accident, there's lost pay, there's medical and recuperation and physical treatment costs that arise in the course of an accident. You may have to replace things that you have lost in the accident, for example, an automobile. And then there are the administrative costs of finding out who should pay for those costs arising from an accident. The sum of those three costs constitute the so-called social costs of accidents. And according to Calabresi and every scholar who's looked at this system, the key is to minimize the sum of those three costs. The private ex ante costs of precaution, the accident losses. We want the accident to be rare and not serious, and the administrative costs of figuring out who's going to pay for these accident losses. Okay, next slide. Precaution costs are under the control of individuals, typically, sometimes corporations, sometimes groups of people, for example, a group of physicians. And one of the first questions we might ask is, how does a rational person, because we're assuming everybody's rational for the time being, how does a rational person decide how much precaution to purchase? Well, first, let's assume there's no tort liability. If there's an accident, you have no obligation to compensate the other person or to be compensated by them. In those circumstances, a rationally self-interested person will only take precaution that provides a benefit to him or to her, not to other people. Right? Why should they protect other people when there's no legal obligation to do so? Well, the problem with that is that people should pay attention to the harm that their actions might cause to other people. You know, it's one thing to decide, I'm going to smoke cigarettes. I like cigarettes. This isn't true, but I'm imagining this. I like cigarettes. And I understand that if I smoke cigarettes, there's a chance that I'm going to get ill and even die. But I've balanced the costs of smoking against the benefits of smoking, and I've decided that for me, it's the benefits exceed the cost, so I'm going to smoke. That's okay. That's fine. That's the way we hope people make decisions. But what they don't take into account is the fact that their smoking a cigarette can impose costs on other people around them. People who don't like cigarette smoke or who might inhale the smoke and get ill themselves. The phrase that economists use in these circumstances is that we need to get the person who's creating these social costs to internalize those costs, to take those costs into account. Next slide. That's the role of tort liability. I'm going to move to a world now in which there is tort liability. If you cause an accident and do so in an illegal way, you are responsible for your own losses and also for the losses of the other person. And let us continue to assume for the moment that there's no insurance and there's no safety regulation. But tort liability can costlessly determine if you caused an accident and injured another person illegally, you have to compensate them. You have to bear the cost of your own losses. Well, what will a rationally self-interested person do if there is tort liability of that kind? It's an important assumption to assume, which I believe to be true, that most actors are acting behind a veil of ignorance. It's a famous phrase from the philosopher John Rawls that he developed in his marvelous book, A Theory of Justice. People are acting behind a veil of ignorance. They don't know if they are going to injure somebody or be a victim. And so we have to consider how rational people will behave if they don't know whether they are going to be the cause of the injury or the victim of somebody else's carelessness. Well, what would rational people do? Well, the best thing they can do is make an estimate of the injuries they would suffer if they were a victim, make a rational calculation, probabilistic calculation about the injuries they might cause to somebody else, and take precaution that minimizes the likelihood and the extent or severity of the losses to oneself, but also to others. You take as much precaution as you can so that, as an economist would say, the last unit of precaution just equals the benefit that that unit of precaution provides. Now, let me stress this. The benefit of the precaution is not just to the individual taking the precaution. It's including an estimate of the benefit that might accrue to other people who might be injured in the accident. Okay? Well, one of the reasons I put it this way, I want to stress this. One of the reasons I put this analysis this way is to show you that the cognitive burden on rational thinkers to take decisions about how much precaution to take, those cognitive burdens are very large. You have to make an estimate of the probability of getting into an accident and the average costs of an accident if you have an accident, both for yourself and for other people. And those are difficult calculations to make. And later, when we relax some of the assumptions like rationality, we'll want to consider what effect it might have on people's decisions to take care that they can't really make very good predictions about the kind of precaution that they ought to take. Well, in summary here, up to this point, um, precaution is taken in a system in which there is tort liability so that every party, not knowing whether they are a victim or an injurer, takes all cost justified precaution. The next slide uh, elaborates on these points and shows you what I mean by this. Suppose that one more unit of care, for example, would reduce the probability of an accident by 0.005. How is one supposed to know that? But forget that for the moment. And that if an accident occurs, given that amount of precaution, the losses are likely to be $100,000. The expected benefit of that unit of precaution is 0.005 times $100,000 or $500. That means that if the unit of precaution costs less than $500, you should take it. If it costs more than $500, you don't need to take it. You shouldn't take it if you're a rational calculator. And if it costs exactly $500, take that unit of precaution, but no more. That's it. Okay. How can the law induce people to make these calculations and to take precaution, all the precaution that is cost justified, taking into account both the cost of precaution and the benefits that that precaution provides to you and to other people? Well, how does the law, next slide, Hitesh, how does the law induce people to make that precaution? And the key is by making it more costly not to take the precaution than to take precaution. In essence, what we say to precaution takers or people who ought to take precaution, whether they're victims or injurers, is that if you fail to take cost justified precaution, which we will determine in litigation, there is an accident, if you failed to take precaution and there was an accident and someone was injured, we may hold you liable to compensate the injured person. And that ex post judgment leading to compensation, we hope, is enough to induce rational calculators to take all cost justified precaution. But I want to reiterate what I've said before. This is an extraordinary amount of calculating for the average person to do. Having taught this subject for 40 years, I can tell you that when I talk to students, I can see their faces puzzled by this. And one of them once asked me, "Who are these rational people you're talking about?" It's a fair question. I'm going to address that on Friday in a larger sense, but it's a fair question. And incidentally, that's not the kind of question you typically get from economics students. They assume that people are rational. That's what they've been taught. But in law school, I think they realize that the world is full of people who are imperfectly rational. I don't like to call them irrational because I don't think many people are irrational. But there are a lot of people who are imperfectly rational. They try to be rational, but for various reasons that I'll go into on Friday, they don't succeed. And we have to create a law for those people as well, not just for the rational few who've had an economics education and view the world through costs and benefits. Let me turn to the next slide. There are two, in almost every legal system, there are two great tort liability standards: negligence and strict liability. I'll talk about the difference, but let me foreshadow that difference by explaining to you the important difference between these two things. A negligence standard says you will be liable only if you fail to take all cost justified precaution. But if you did take all cost justified precaution and there is an accident, you're not liable. All we ask is that you take all cost justified precaution. We'll see the economic analysis of why that's, in some circumstances, a really brilliant idea. But I'm not exaggerating to say to you that until law and economics came along, the analysis about negligence versus strict liability was not very clear. But I hope that by the end of this lecture, you'll say, oh, I see the difference here between these two great liability standards. Negligence proposes to exonerate or excuse from liability anyone who caused an accident, but who took adequate precaution. And what happens in that case, if the person took adequate precaution, but an accident occurred, is the injurer has to bear his or her own losses. Okay, so you can escape liability if you take all cost justified precaution under the negligence system. Under the strict liability standard, you're liable if you caused an accident. It doesn't matter how much precaution you took. You can take none, you can take just exactly the right amount, you can take tons of precaution. It doesn't matter. The only standard, the only cause of or method of determining liability under strict liability is causation. Did you cause the accident? Now, there are lots of puzzles, as you know, about causation, but this is the great difference between negligence and strict liability. Under negligence, yes, we have to determine if the injurer caused the accident, but we will excuse the injurer from liability if he or she took cost justified precaution that was just exactly the right amount to minimize the costs that would arise from an accident. But under strict liability, yes, you caused the accident, and therefore, regardless of what you did, you have to pay for the victim's losses. Okay, let me put this in a little bit of algebra. I'm not going to torture you with graphs or elaborate equations. Those are in the book. So if you're looking to be tortured, please look at the chapters of the book that I sent to Renita. Let X be the amount of care taken by the injurer, whatever it is. And let us assume, which seems reasonable, that the larger X is, the larger the amount of care taken by the injurer, the less likely and the less severe an accident is going to be. Now, among all of the options for the amount of precaution to take, let us designate X star as the social cost minimizing level of care. The total social costs, the precautionary costs, the accident losses, and the administrative costs are going to be minimized if the injurer takes X star amount of care. And therefore, we are allowed to define negligence algebraically in this simple way. The defendant, the injurer, is liable if the actual amount of precaution he or she took, X, is less than X star. And the defendant is not negligent and therefore not liable if the amount of precaution that he or she took is greater than or equal to X star. Okay, that's easy to say, but I wanted to use that as a definition of precaution, or how you determine liability in a negligence system. Let's look at the next slide. Some other things that we need to answer are this. The great difference between the negligence standard and the strict liability standard is that there is something you can do if your activities are judged according to a negligence standard. There is something that you can do to escape liability, and that's take an exonerating level of care, the cost justified, social cost minimizing level of care. There is no exoneration in strict liability. If you cause the accident, you're liable. Now, the question that arises that I honestly believe that law didn't do a good job of answering until law and economics arrived. This question, why should there be an exonerating level of care, is extraordinarily simple to answer in the economic analysis of tort liability. And that's to return to our thought experiments about rational people making decisions. We've been focusing on what the injurer did. Did he or she take a cost minimizing level of care? And if they did, we say that under the negligence standard, they are exonerated or excused from liability if they've done that. Well, we haven't considered the victim. And remember, you don't know whether you're going to be a victim or an injurer. What will the victim do if she knows she's going to be the victim? If she knows she's going to be the victim, what's the best thing for her to assume about the behavior of the person who injured her? I'm pausing for you to tell me the answer, but I'm not listening. I'm going to tell you. The answer is that a rational victim or potential victim will assume that she is going to be injured by a rational injurer. And if so, that rational injurer will have taken all cost justified precaution. Right? Everybody's rational in this story. And if I don't know if I'm the victim or the injurer, I might be the injurer. and thinking about my future, if I do injure somebody, I know that I will be excused from liability if I've taken all cost justified precaution. So in thinking about what I should do if I'm the victim, I should presume that I'm going to be injured by an injurer who has taken all cost justified precaution. What does that mean? They will be excused from liability for my injuries. And if they are excused for liability for my injuries, I have to bear the cost of my own injuries. I'm the one that has to replace the damaged car. I'm the one that's going to be uh, 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 have to figure out a way to pay myself for the work that I have lost because I was injured and in the hospital. I'm the one that's going to have to figure out how to pay the hospital and the physicians for the care that they've given me. If that's true, if I'm right to assume I'm going to be injured by a rational injurer who's taken all cost justified precaution, then I have to take precaution to minimize my own anticipated losses if I'm injured by a rational injurer. I know this sounds crazy, but we will relax the assumptions. But I think this very simple model that assumes rational decision makers, no injuries, no insurance, no safety regulation, and zero litigation costs. I think the value of doing this is it cuts out all of the complications and allows us to see what is at the heart of the negligence standard and the strict liability standard. And here's the key. The negligence standard induces everyone to take care. And it does this because it provides a way for you to escape liability. If you take all cost justified precaution and the injury is going to be judged according to a negligence standard, you'll never be held liable. But you also need to think about the fact that you might be the victim who's injured by a person who took all cost justified precaution. So the great value of the negligence standard is precisely because we do not know whether we're going to be a victim or an injurer. The negligence standard alerts everybody to take all cost justified precaution. And thereby, the negligence standard minimizes the social costs of accidents. The sum of precautionary costs, accident losses, and administrative costs. I don't know how the law stumbled on this incredibly sensible method of getting everybody to take care. But here, next slide, please, Hitesh. The key with negligence is that it induces both an injurer and a victim to take all cost justified precaution. The next slide as well. Let's go to number 4, please, Hitesh. The conclusion, as I've mentioned, is that negligence induces both potential victim and potential injurer to take care. Now, in what circumstances is this the best system for determining liability for accident losses? It's under circumstances of bilateral precaution. By that phrase, which law and economics invented, bilateral precaution is precaution that can be taken by either the victim or the injurer to minimize the social costs of an accident. For example, automobile accidents are the classic example of bilateral precaution. There is something that every driver, whether they are going to be injured by somebody or injure themselves somebody, this is a situation of bilateral precaution. Both victim and injurer can take actions to minimize the social, minimize the social costs of accidents. This is a puzzle, by the way. I have to tell you this to make you realize that all of these scholarship things are organic, they're growing, they're changing. This is not the way Judge Posner presented the economics of tort liability in the first several versions of his magnificent economic analysis of law. He asked the court to compare the costs of precaution of the victim and the injurer and to assign liability to the person who had the greater cost of precaution and didn't take them. That's impossible for a person ex ante to know. You cannot know anything about the other person. You can't know ex ante whether you're going to be a victim or an injurer. And so you have to, using your rationality tools, decide what to do, given that I don't know whether I'm going to be victimized or injure somebody. And the answer under negligence is figure out what's going to minimize the accident losses and take that amount of precaution. And we hope everybody has done that so that if there is an accident where two cars crash into each other, both parties will have taken care and the total costs of the accident will have been minimized by that. Okay, I suspect there will be questions. Let's go to the next slide, Hitesh, because we're running out of time. Let's turn to the alternative liability standard, strict liability. Strict liability is the alternative. And if you take a law school class, you will learn that strict liability is reserved for situations of, quote, abnormally dangerous activities, unquote, such as using dynamite. If you're making a road, you're going to probably use dynamite to help you clear a path to make the road. And if you do something as extraordinarily dangerous as using dynamite, you are going to be held strictly liable. There are famous cases, for example, where people using dynamite caused a nearby farm that was raising animals. It caused those animals to be terrified and to run around and kill one another and caused really big damage to the farmer who was raising those animals. And the people who were using dynamite were held strictly liable. On what ground? Using dynamite is an abnormally dangerous activity. If you keep a tiger as a pet and somebody comes into your house and is injured by the tiger, you're going to be held liable on the strict liability standard. The key difference between negligence and strict liability is that under strict liability, there is no level of care that will excuse you from liability. If there is an accident and the injurer caused it, he will be liable for the victim's losses. Recognize this point. Strict liability is a cheaper system to operate than is negligence, because you only have to investigate one thing. What did the injurer do? You're not really interested in whether they took a lot. You don't need to investigate their precaution. All you need to do is find out if their actions caused the harm. Now, that's not a trivial investigation, I grant you, but nonetheless, the administrative costs of strict liability are significantly lower than under negligence. I should have said this, and I will reiterate it later, but negligence is typically called not just negligence, but negligence with contributory negligence. And that second phrase, with contributory negligence, focuses on the actions of the victim. If the victim didn't take enough care, even if the injurer didn't take enough care, the victim cannot recover under the standard of negligence with contributory negligence. Only victims who've taken all the precaution they should have taken can recover from an injurer who didn't take all the care he should have taken. That's the negligence standard. And by the way, just for completeness, in almost every legal system, there are now alternatives to the negligence system, and that is what is called comparative negligence, where the court evaluates the amount of negligence on behalf of both the victim and the injurer and assigns liability to the one of those parties who didn't take enough precaution. That's the standard in the state of Illinois and in most states in the United States today. And let me make this comment too. Comparative negligence is a very expensive system to operate because it requires the court to make determinations of the relative amounts of precaution that the two parties took. And the general point still exists. Negligence is a more expensive administrative cost than is strict liability. Having said that, I want to return to the assumption that we've made throughout these lectures. The legal system from an economic point of view is to be looked at as an ex ante system. How does the legal system prevent the sort of thing that might lead to a legal controversy, to litigation? In many ways, I would defend this if we had enough time. In many ways, litigation is a testament to the fact that people have not paid enough attention to the law. Something has happened that should not have happened. Their lawyers should have guided them in such a way that litigation doesn't happen. Okay, I mean, I'll leave that point aside. I want to turn to this question in the few minutes remaining to me. Under a strict liability system, how will the person who is going to, whose actions, the injurer, how is that injurer going to behave? Here's something that nobody believed to be the case. And it's a theoretical assumption, may not be true in practice. I don't know. Nobody's done that empirical work. But under the sort of assumptions we have made about rationality and the like, an injurer who knows he's going to be held strictly liable will take exactly the same amount of precaution he would have taken if he was going to be held liable under a negligence standard. Why would he ever spend too much on precaution? It's not going to exonerate him. He's going to be held liable if he caused the accident. If taking more precaution reduces the probability of the accidents occurring or the losses that arise in the event of an accident, yes, he'll take more precaution, but only up to the point where the cost of another unit of precaution is exactly equal to the benefit of the precaution. That minimizes his liability. Any other additional costs on precaution it's just money wasted. If he's going to be held liable, additional precaution's not going to excuse him, and it's not going to further reduce the expected losses to the other party. So a rational injurer who knows he's going to be evaluated under the strict liability system is going to take exactly the same amount of precaution as he would have taken had he been liable under a negligence system. Interesting, that's not what the law taught. So what's the difference between strict liability and negligence? The behavior of the victim. The victim, remember, under strict liability, doesn't have to take any precaution at all because the injurer is liable if he caused the accident. Doesn't matter what the victim did. So the victim might not take any precaution at all. They might not take enough precaution. But that's okay if we're assigning strict liability in the right circumstances. Why is that okay? It's okay. I think this is on the next slide, Hitesh. It's okay if the victim doesn't take precaution, if the victim can't take precaution. That's the difference between negligence and strict liability. The injurer knows he or she is going to be the injurer ex ante before the injury occurs. The victim knows ex ante that there's nothing they can do to reduce the probability or severity of an accident. This is a situation that we call in the literature unilateral precaution. A great example of this is airplane accidents. Are passengers in an airplane, a commercial airline, at risk of liability? Well, yes, if they try to do something they shouldn't do. But if they're just passengers, there's no way those passengers can reduce the probability or severity of an accident except by not flying. But if they want to get from point A to point B quickly and they want to fly to do it, the only people that can be induced to take care are the airliners, the airline, the manufacturers of the so-called airframe, the airplane itself, and the people who are operating the airplane as employees of the airline. This is a case of unilateral precaution. Or if you want another example of unilateral precaution, think about injuries that occur on the ground if a plane falls out of the ground and causes injuries on the ground. There's nothing that people on the ground could have done to minimize the probability or severity of an accident. This is clearly just unilateral precaution. The airline's liable for the injuries, if any. Okay, though that's the ideal world in which we sort out the differences between strict liability and negligence. And I'm sure you've got questions and I'll get to those, but I want to do one last thing. Let's relax the assumptions. Next slide. We've assumed rational injurers and victims, no insurance, no other social policies such as safety regulation designed to induce precaution, and no litigation costs. And we've reached the conclusion under those assumptions that tort liability can induce rational people to take care. And there are two different standards that we're going to use depending on whether there's bilateral or unilateral precaution in the particular accident that has arisen. Bilateral precaution, if there's something that both the victim and the injurer could have done ex ante to minimize the social costs of accidents by taking precaution. Negligence is the social cost minimizing standard. If the only person who could have reduced the probability or severity of an accident is the injurer, and there's nothing that victims can do, then strict liability is the appropriate standard. Now, I want to relax the assumptions, but I also want you to think about something else before I do that. And that is, what happens if we make a mistake in applying the tort liability standard? What if we use negligence to evaluate a situation that should have been considered under strict liability? And conversely, what happens if we use strict liability in a situation of bilateral precaution? There is something that the victim could have done to reduce the probability or severity of an accident. I'm going to leave that as a final exam question for you to sort out the problems that might arise if we use negligence in a situation of unilateral precaution and use strict liability in a situation of bilateral precaution. It's an interesting question, And by the way, it's a question that you could not have answered without the benefit of law and economics. As I said, the only reason for the default liability standard throughout the Western world, and I assume most of the world, the default liability rule is negligence. Strict liability is reserved only for abnormally dangerous activities. But I think you can now see with the help of the economic analysis that there are some other considerations that that we might consider. Okay, let's relax these assumptions and see what happens to our model. I'll try to do this quickly so that we can get to your questions. Remember, I said that my law students, unlike economic students, somehow said, "Who are these rational people you're talking about?" And I've said, and I firmly believe this, that people may be imperfectly rational. They make mistakes. They know they're going to make mistakes. There's no room, and there is no theory, to my knowledge, in economics of mistake making. But one of the great virtues of considering the law is it's an interesting philosophical subject, but it's also a very practical subject for trying to organize a society, for getting a society to work as well as it can possibly function. The rule of law is there's nothing else quite like it. It's certainly the best way we know to organize a society. And so the practical considerations in the law have to be considered. If we presume people to be rational, but they make mistakes, how can we deal with those circumstances? I'm going to return to that problem on Friday in the last lecture. What would tort liability look like if people are imperfectly rational? Do we still have the same distinction between negligence and strict liability? Well, we'll see. It's not a lot different, but it is slightly different. The next assumption I want to relax is insurance. There are two central kinds of insurance, as you know: first-party insurance and third-party or liability insurance. First-party insurance is the kind of insurance that I have, you have, that compensates me in the event that I lose, I suffer an accident. My automobile insurance will pay for the repair of my car. My medical insurance will pay for my medical care, and so on and so forth. Third-party liability insurance is I pay somebody to assume that liability for me. And what happens is if I cause harm and I have liability insurance, my insurer will pay the victim. Okay? Now, the question that arises, and it's a sensible question, is if parties have first-party and third-party insurance, aren't their incentives to take care reduced? If I know that I can get my car repaired, and I can go to the hospital and get myself repaired, my incentive to take care may be reduced. And I know too, if I cause a harm, I'm not going to have to pay for that harm. My insurer will pay for the harm. Well, wait a minute, that's not the way insurance typically works. We know that there is a moral hazard problem with insurance. Now, moral hazard, I think you all know this, so forgive me for going into it again. Moral hazard describes the situation where somebody's precautionary behavior is reduced precisely because they have insurance. If, for example, I have house insurance, home insurance on my home here, that will compensate me totally for any harm that occurs, why should I take care to make sure that my electric system is working properly, that I didn't leave the stove on when I left to go shopping, and so on and so forth? Insurers know this, and they've known this for 3 centuries. People who have insurance have an incentive not to be as careful as they otherwise would be. And insurance companies deal with this moral hazard problem by two things: co-insurance and deductibles. They're not going to compensate you fully for your losses. They'll only compensate you for a percentage of your losses, 80%, 90%, but not 100%. That co-insurance means that they will pay only a fraction of the losses. A deductible means that a fixed dollar amount is something you have to pay. So, for example, my automobile insurance has a $500 deductible. So I have to pay for the first $500 worth of damage that I have done to my car. And that exists in the insurance world to minimize the cost of moral hazard by preserving an incentive for me to take care. The problem of moral hazard is addressed. Adverse selection arises because it's impossible for an insurance company to charge every single person an insurance premium, that is the price you pay for having insurance. It's impossible for an insurer to determine the expected accident losses for each individual who comes to them. So what insurance companies do is they create classes of insurers: men and women, men under the age of 18, men over the age of 65. And the way they create these classes, and the reason for creating these classes, is that they think that these classes have different likelihoods of having accidents, and that by dividing people up into classes and charging the class different rates depending on which class you fall into, that they will minimize the likelihood that somebody won't take enough care. But there's a problem with establishing a class. And the problem is that the insurer will take the average for any class they've determined. They will take the average likelihood and extent of injury for that class and make that average in the middle the price they charge to everybody in the class. Now, if you're above average, that price seems a little, it's too high for you. You know, you're careful. Within your class, you may be a male under the age of 18, but you're a very cautious male under the age of 18. So the insurance premium seems to you to be a little bit too high. Maybe that will induce you not to get insurance. But the other problem is that for the other half of the class, let us assume males under the age of 18, that insurance premium seems like a very good deal because you're careless, you don't pay attention, and you know you're more likely to have accidents than the insurance company thinks you are. So just because of that difficulty of the insurance company charging exactly the right price to you, we get what is known as adverse selection in insurance markets. The people who find insurance most attractive are the people who know that they're careless or prone to injury. They've got particular information about themselves they don't want to disclose to the insurance company, and they take too little precaution. How does the insurance company deal with that? Through something called experience rating. Experience rating is the process by which the insurer decides, we're going to look at your record. If you've had a lot of accidents in the last couple of years, we're dropping you. We don't want to insure you anymore. You should have told us that you were accident prone, but now we know. And as a result, we're not insuring you anymore. Okay, that's the way to deal with adverse selection. There is something called a death spiral because of adverse selection. I don't want to talk about that because it's a particular problem in health insurance markets, but it is a real problem that insurers face. Instead, I want to mention the system. I'm going to finish in 4 minutes, I promise. I want to raise the issue of what's called subrogation. What's subrogation? Subrogation is the legal doctrine that allows your insurance company to stand in your shoes in the event that there's an accident that leads to litigation. So if you're injured in an accident, your insurance contract may allow the insurance company to pretend to be you, not pretend, to be you and represent you in the litigation that might arise from that accident. That's true for both victims and injurers. Disputes about what happened in an accident are typically dealt with by subrogation, which means that most litigation, in point of fact, is between insurance companies, not between individuals. It's really between insurance companies. Now, what's the summary of all of this? I think the summary is that because of the existence of first-party and third-party insurance, and because the insurers have dealt with moral hazard and adverse selection, the incentive to take care is not reduced by having insurance. Insurance provides a method of compensating people for accident losses. And because I think the insurance market is really pretty efficient, I don't think that when we introduce the idea of insurance, we need to change the model. The model still describes what the differences between negligence and strict liability ought to be. And the presence of insurance does not minimize or affect the minimization of social costs that we're looking for. The last thing I want to talk about, well, two last things. I'll just point these out to you and let you deal with these. Litigation costs. As we know, litigation costs are very high. A very good lawyer can cost you in the United States between $500 per hour and $1,000 per hour of work. So litigation costs can be extraordinarily high. What's the impact of that? I'm not going to talk about this because I've run out of time, but on the 19th slide, I try to demonstrate to you that even if litigation costs are high, they do not affect the ability of the tort liability system to induce potential victims or potential injurers to behave any differently. The last thing I want to talk about, and I think it's one of the most interesting topics, is the last slide. What if there is safety regulation? Does safety regulation interfere with the tort liability system? And this is a real situation. Safety regulation, which usually arises from the legislature or an administrative agency, safety regulation is designed to accomplish exactly the same thing as the tort liability system, the minimization of the social costs of accidents. And safety regulation explicitly addresses the ex ante situation. So, for example, safety regulation requires automobile manufacturers or anybody who sells cars in the United States to have certain safety features built in to the automobile. And I can tell you from having bought a new automobile in the last year, the safety features are incredible. We're not far away from the world in which we're going to have what are called autonomous vehicles that drive. There are a lot of autonomous vehicles already on the road. For example, gigantic trucks that carry goods from long distances. Many of those are being driven autonomously by a computer. There is usually a person sitting there, but they don't have to hold the wheel. I can't wait for this world to come because I take a lot of long trips on an automobile to go see our grandchildren. In one direction, it's a 12-hour drive. In the other direction, it's a 3-day drive. And I have to spend time paying attention to what's going on. I would love an autonomous vehicle. I get into the car and I say, take me to 508 Creek Crossing Road Northeast in Vienna, Virginia, by the most direct route possible. And then I can sit back and read a book or sleep or talk to my wife or play cards with my wife. And when we wake up, we'll be delivered to the endpoint that we asked our car to take us. Autonomous vehicles, by the way, will lead to a significant minimization of the social costs of accidents. Approximately 45,000 people are killed every year in the United States in automobile accidents, and hundreds of thousands are injured. The best estimate we have is 94% of those accidents are caused by human error. And autonomous vehicles, they will make some mistakes, but nothing like that. So the technology is going to reduce the social cost of automobile accidents in the next 10 to 20 years significantly. Anyway, I've talked too much, and I'm perfectly happy to answer your questions. And let me see. Oh my goodness. There are a lot of questions, aren't there? Professor Kumar asks, a rational injurer would not incur costs on some precautions because it is not rational, while the victim, who has no idea of what precautions to take, is expected to take precautions and incur the cost on the same. Yes, exactly. But if the rational injurer doesn't take all cost justified precaution, he or she is going to be held liable, and particularly going to be held liable if the victim took all cost justified precaution. That's a nightmare scenario for a rational potential injurer. And we are all, after all, potential injurers. We're also potential victims. So the hope, and it's a hope, the hope is that rational people will take all cost justified precaution, regardless of whether they're going to be injured or injure somebody else. That's the hope of the tort liability system. It's also hope, by the way, of safety regulation. As I indicate on the slide that I didn't go through, safety regulation and tort liability can work together. And one of the questions I will give you on the final exam is this: if compliance with all safety regulations exonerates an automobile manufacturer from any private liability, will there be too many accidents, or will those accidents be too severe? I will give you the final exam on Friday, and you can have it back to me by the following Monday. I'm kidding. There's no exam. Another question from Dean Nagar. Will aggregate precautionary costs be lower in cases of strict liability since the victim does not take precaution? Great question, and the simple answer is yes. If strict liability is being imposed in the circumstances in which we believe it ought to be, that is, situations of unilateral precaution, the only person who takes precaution is the injurer, and the victim has no duty to take care, and therefore will take zero care. And the injurer takes only the amount of precaution he or she would have taken under negligence, that is, all cost justifying precaution. So you're right. The aggregate precautionary cost is minimized under strict liability, and it's less than that under negligence. Another question, does experience rating also lead to higher premiums? Yes. In some states in the United States, we have what's called uninsured motorist insurance provided by the government. And that's for people who have been invited out of the system. It's extremely expensive. And some insurance companies will increase your premium, the price you pay for having the insurance company, if you have a lot of accidents. They might not terminate you, but they will raise the premium to be extremely high because their experience indicates that you were misclassified. You are more likely to have accidents than they presumed when they first wrote a liability insurance policy for you. Here's a great question. Can strict liability or a duty of care be excluded by way of contracts? Can we convert on the type of liability by virtue of a contract? What a great question. In theory, yes. And I'll have to think about some examples and try to get back to you on Thursday or Friday. In theory, the appropriate tort liability standard that is used or liability itself can be determined by contract between the injurer and the victim. For example, it could be that before you have a very serious surgery to correct a health problem, it could be that the insurance company asks you, or the hospital asks you, or the doctor asks you to waive your liability against him or his staff, or her staff, for any injuries that arise in the course of the surgery. And by the way, that's a great example of strict liability. You're anesthetized. You can't sense anything that's going on during a surgery. So if you come out of the surgery and you've been injured in some way, there's nothing you could do. You were anesthetized. You don't know who injured you. That's a great situation for strict liability. And many hospitals try to limit that by having a patient waive their liability by contract before they have the medical procedure. And by the way, warning people of dangers by contract, by communication, is frequently a cause for minimizing liability. It's a great question, and I'll try to do better. How do you attribute liability in respect of autonomous vehicles? So will it rest on the manufacturer or that of the owner or software provider? Absolutely right. That's exactly right. In fact, the great economist and law and economics scholar Steve Chevelle wrote an article about this. And I'm looking for a pen because I'm going to send that article to Dean Nagar so that she can distribute it to you. Steve Chevelle, who's a very good friend of mine, is one of the great law and economics scholars in the world. And he wrote an article on the economics of liability in the world of autonomous vehicles. And you're absolutely right. The liability is not going to be, it'll be on the software. You're right. It's on the software that the manufacturer uses. If that software is flawed in some particular way, the manufacturer is going to be held liable. It's likely to be a situation of strict liability. The only circumstance I can imagine, but I wonder if Steve probably addresses this. What if somebody grabbed the wheel and turned off the autonomy aspect and then had an accident? Can we determine that after the accident had occurred? Well, assuming that we can, the liability shifts from the software manufacturer or the automobile manufacturer to the individual who turned off the system. There have been accidents, by the way, fatal accidents, in which a car, the Tesla, I don't know if there are Teslas available in India. The Tesla can be a fully autonomous car. If you turn it on, you have to turn it on. You, the driver, have to turn it on. And there have been circumstances in which people turned it on, in circumstances in which Tesla had warned the owners not to turn it on and gone to sleep. And the car is driving itself, and a car has an accident, and the person is killed, and their estate sues Tesla, and Tesla has not been held liable if people were using the autonomous vehicle in a situation in which it ought not to have been turned on. Great questions, as always. This is so much fun for me.
Can I ask one question, sir?
Of course.
With regard to insurance, you mentioned that it does not minimize the liability, and also it does not give the free rider of negligence. But don't you think counterly it is providing you to be a negligent? And you also find from your point of view, liability will be what when you have insurance?
I didn't get the first part of the question, so let me ask you a question in return. Are you talking about a situation in which strict liability is being used when they ought to have used negligence, or using negligence when they should have used strict liability?
I was adding one factor of insurance and then trying to discuss that. Don't you think that insurance, if you have component of insurance and keeping the strict liability aside, even you negligent, yeah, if you have liability, then also you are induced, yeah, you are incentivized, yeah, you maybe go if in context of financially, not in context of the otherwise.
Yeah, yeah. I take it that you're asking the question, and correct me if I'm wrong, please. That if you have insurance, your incentives, even with co-insurance and deductibles and subrogation, even in those circumstances, you may be induced not to take as much care as you otherwise would.
Yes.
If that's discovered, and if it's discoverable that you took too much, you didn't take enough precaution, the insurance company is probably going to not defend you. They may compensate, but that's probably the end of your relationship with your insurance company. They don't cheerfully pay for the accident losses unless you complied with all the relevant safety standards yourself. I may have insured myself, but I didn't maintain my car. You know, the lights don't work properly, or only one of the headlights work and none of the taillights work. If I didn't maintain my car, that's part of the insurance contract. I have a duty to do that. And if I didn't do it, the insurance is not going to pay for anything. Now, I think a relevant question, it's a very good question, Hitesh. A relevant question that flows from that is what do we do about the fact that most people don't read their insurance contracts very carefully? And they may assume, as I think your question in part suggests, they may assume inaccurately, but nonetheless reasonably, that if they have insurance, they're covered. And so they can do almost anything they want to do. Shoot, I ran through a red light. Oh gosh, I wish I hadn't done that. But that's okay. My insurance company will pay in case there's an accident. Yeah, you know, there must be people who behave that way, but very few of them are economists or have got a good grade in an economics class. I think I know that my insurance providers all say this to me: you're our ideal customer. We don't have to persuade you to get insurance. You understand what the value of insurance. And then I engage them in conversation, and I learn that the vast majority of people don't want to buy insurance. I had a colleague and a co-author, by the way, who we were much younger at the time. We were in our 30s. And we were writing an article together, and the subject arose of how much insurance do you have? Do you have life insurance, for example? And I said, of course I've got life insurance. Something might happen to me, and I don't want my wife and children to have to worry about what comes next. They'll have plenty of money. And he said, "No, I don't have insurance." I said, "Why not?" And he said, "My wife's a lovely woman. Somebody will marry her and take care of her and the children." It's a form of insurance, but my goodness gracious. I buy almost any insurance that's made available to me. So I'm the ideal customer, and I probably shouldn't be talking about it because uh, I think insurers struggle to sell their product.
So can you also think about asymptomatic patient during COVID? How far this liability and negligence will be taken? Those who are asymptomatic patients, they don't have any symptoms, either coughing, fever, but they are COVID patient, and because of them, it is spreading. And so, how far, matlab, we, though it's not tort issue, but still, if you want to see from negligence or from the liability point of view, how it can be, because there is a social cost involved.
Absolutely. Absolutely. And it's a great question. And I've agonized about that too. Do people get vaccinated against a communicable disease, an infectious disease, just to protect themselves? Or are they also doing it uh, because there's a social cost of not getting vaccinated? Uh, I think one of the ways, as you know, I will never say, or very rarely say, a good thing about the Trump administration. It was a nightmare. But one thing they did absolutely right was to make the COVID vaccine free. And I think this is a very good example of the question you're talking about, Hitesh. It's an example of the government subsidizing the consumption of something so as to induce people to take an action that benefits them but also benefits other people. Um, what else could the government have done? Well, it could forbid people, as they did in Canada. Uh, we all have these cards, these vaccination cards that tell us anybody how many times we've been vaccinated and when we were vaccinated. And in Canada, you were required to show that card to anybody when you went outside of your house, when you went to the grocery store, when you went to a movie theater, when you went to your place of work. And if you were not vaccinated appropriately, they wouldn't admit you. I can tell you that Canada might stand for that sort of thing, but Americans would never stand for that sort of thing. So I think going farther in our country than making the vaccines free by, for example, compelling people to get vaccinated, by requiring them to show a card, for example, uh, Americans wouldn't stand for that. And as a result, we have very incomplete vaccination rates. I think the vaccination rate in Champaign County, where I live, is 80% on average. 80% of the population on average has been vaccinated. 95% of those 65 and above have been vaccinated. A much smaller percentage of other people, other groups in society have been vaccinated. But public health people tell us that if 2/3 of the people are vaccinated, that can lead to herd immunity. I'm not so sure because the number of cases is going up significantly in our county, largely because the students have all come back to go to college. We have 55,000 students coming from all over the country and all over the world. And I don't go over to the university because it's a place where you're likely to contract COVID. There are just too many people coming from too many different places. That's a good question, and uh, you know, if we had more time, we could consider whether you could impose liability on people who were contagious and didn't get a vaccine and did not isolate themselves and caused other people to get COVID. My wife and I both had COVID in January of this year, and we don't have any idea where we got it. We wear masks whenever we leave the house. We're vaccinated and boosted, as they say, and yet we got COVID. It was not. It was like a bad cold because of the vaccination, but somebody gave it to us. I don't know who. I don't know where. And I don't want to accuse anybody because I don't know that they did it. It's a good question, though, and it's generalizable beyond COVID. Any infectious disease. Should somebody who spreads an infectious disease be liable to the people who he or she infected? I'm sorry, I should stop talking. You've got more to do.
Professor, one last question, if you permit me.
Of course.
This new automobile that you bought,
Yes.
does it also have a law and economics number plate?
It does. It does indeed. I have a license plate that says Law Econ, and I love it. I'll tell you how much I love it. The reason we bought a new car is that one of our old cars, the one that had that license plate, was destroyed in an accident. My wife was driving the car and somebody pulled out and smashed into her, and the car was totaled, as we say. She's okay. She's fine now. But I think she'll never forgive me for this. But one of the things I insisted on getting back from the car was the license plate, because I love that license plate. And by the way, people stop me all the time and say, what does your license plate mean? And I get to give them a little lecture and tell them it means law and economics, a very important subject. And like the audience here, they get bored with me after, that's enough. I don't want to hear anymore. I just wanted to know. Well, thank you for listening to me. I love to talk about this subject. I love the fact that I have this book that I'm going to read part